Welcome back to Case Closed. I'm Charlie Langton. Now, continuing on with Where There's a Will, There's a Way. Let's hear from the defendant.
All right. Well, Ms. Chavis, what do you have to say?
Your Honor, when my husband was in the hospital, I was right by his side till he died. I even fell and got injured during the snow.
You what?
I'm from North Carolina. I'm not I can't talk with the people up here, but.
Well, we can't talk with you down there. I guess that's mutual here. Go ahead.
I was in the hospital with my husband from November the 20th to December the 20th. He passed away. And Patricia come and wanted me to sign power of attorney papers over to her at my home when my husband was in the hospital for me and him. Then she come the next night and she wanted to take the stuff out of the house. And I told her no. I said, my husband is not even dead. You're not taking nothing out of this house. And my husband would not give her anything out of there when he was a living. She wanted it when he was a living, Judge, and he wouldn't give it to her.
But he's dead now.
Yeah.
And the will gives everything that he has to her.
Well, he wouldn't give it to him when he was a living.
But he's not living. Did you read the will?
I ain't never seen it, sir.
Well,
I didn't know
so you
nothing
didn't
about
read it. I read it.
I don't know nothing about it. He told her.
Well, you know about it now.
Yeah. He said if I wanted to give him something, that was fine. But he would not give it to him while he was living.
But he's not alive.
Yeah, I know,
as you well know.
Yes, sir.
There is a will that I have that I've pretty much read. It's not a long will. It looks like it's signed by him that gives everything he has to the plaintiff in this case. Now, why can't she get the stuff that belonged to him? Why is there a problem here? Because that's what the will says. My question to you is, why can't she get everything that your husband had? Because that's what the will says. Why is there a problem?
I didn't know about no will, sir.
Well, now you know.
And then when they was in the hospital with my husband, they put out pictures when my husband was dead.
That has nothing to do with it.
Well, I didn't know nothing about no will.
Well, I guess you know now, don't you?
Yeah, but when I come from the hospital and the way I was treated at the funeral, they didn't even recognize me as his wife. I was so upset.
Okay.
I threw a lot of stuff away because I was really upset, Judge, because I had been treated so badly.
Well, it doesn't matter. It doesn't matter at this point. The will gives your husband's property to Ms. Lepard. Is there any, ma'am, is the only property that you're talking about are these personal items?
That's all.
Because you've got to be careful here. This will says that you're entitled to get everything that he had.
And you know what? Let me just be totally clear about this. I never wanted anything except for the personal items. I said, Jackie, you have the house, you have a car, you have a truck, you have the van, you had access to any money, which her signature was on the closing receipt. They closed out the savings account. That's all. It has nothing to do with me. That was my dad's. They were married. I respected her and I respected his decision. All I wanted was the personal items, and that's what I told Jackie. Jackie knew that from the start.
This will, as I said, says that you're entitled to everything that your father had, okay? Or your uncle. I don't know what he had in his estate, okay? When somebody dies, there potentially is a probate estate that could be opened, and the assets that belong into that estate go to certain individuals. You are named in the will as getting his property, and it says everything, okay? She may have certain rights to that property as his surviving spouse. It depends on what was in his probate estate. And when I say probate estate, that has a very technical legal definition to it. It's not necessarily things that he owned, the way you might think of it, the way non-lawyers might think of it. A probate estate is statutorily defined. The will says you are entitled to that, possibly subject to certain rights that the surviving spouse has. And it gets a little complicated when you get into all of that. And we're not going to get into that today because this is the wrong court for it. What you have to understand is that if you do get a judgment here today, and then later on you decide that you want what you may be entitled to get in this probate estate, and you go to probate court to get that, because I can't give you that. That would have to be done in the probate court. By getting this judgment here today, you may foreclose your opportunity later on to get what you might be entitled to, which might be a lot more than just these personal items. I don't know, because I don't know what's in his probate estate. You understand that? Because what could happen is if you do that and you go to the probate court, the other side may very well argue that the matter has been already decided here in the district court and that the probate court can no longer open up the probate estate and give you what you may be entitled to get because of this case here. So you're running that risk. Now, I just want to make you aware of that. You still want to go ahead with this, knowing what could happen.
I do. It has always been from the beginning. I simply want, we have a list of personal items.
Let me see the list. All right. And I don't know if I'm going to read the whole list here. Dining room table and chairs.
Those actually belong to us. They weren't.
Well, Shirley Temple doll, Woody Woodpecker puppet.
These are all personal childhood things that were in the attic.
Chinese tea set, Cabbage Patch dolls. Other assorted toys and personal items.
Pictures and
hand-painted ceramic items.
those were painted by my mother.
The guns, you're not entitled to get the guns.
Well, my daughter is.
But you're not.
But my daughter.
Okay, so that's not part of this. Guns might be the most expensive thing here. You list the guns as having a value of $1,100, $1,175, I think, if I added it up quickly. That's almost half of what you're asking for.
Well, actually, what we're asking for, that list, what we tried to do, the value of it, we figured was over $4,000. And then to be fair, to depreciate it, because the stuff is old and, you know, we try, like with the pictures, I have, again, no idea. So we settled for $2,400.
All right. So this is what you want. What you're telling me is that if your uncle had other assets, maybe liquid assets, that you may be entitled to, you'd be willing to give that up to get these items, except for the guns.
Right. I'm perfectly.
We want to be fair to Jackie.
Well, I understand you wanting to be fair, but that's not the issue that I'm dealing with, okay? This is strictly a legal issue, and what I have to do is determine what, if anything, you're entitled to, given the fact that your uncle died with a will, leaving you as his legatee, and given the fact that he had left a surviving spouse, okay? So fairness, you know, from my end of it, is not as important as following the law.
Now, did I just hear the judge say that fairness is not as important as following the law? I always thought the two were the same. Let's see what the judge rules.
Ms. Chavis, I think you got to give these items on the list to her.
I don't have them.
Where are they?
I don't know all the stuff she's talking about. I've never been in the attic.
You don't have any of the pictures.
Yeah, I got some pictures.
Where's my mother's picture?
At the funeral, Your Honor, I was treated so...
I don't care about that for the millionth time, all right?
Excuse me.
I do not care that you were treated poorly at the funeral. That's not an issue before me here today. The will is... Ma'am, I don't want to hear it. That's not an issue. That is not an issue. That is not an issue here in front of me today, okay? I don't want to hear about that anymore. That's not something that we have to decide.
Well, if they would have told her there was a will, she would have given him anything.
Well, she knows now.
Well, that's after the fact. Stuff's already been thrown away. After they treated her like garbage and put his first wife's pictures out all over the funeral home and displayed them in the hospital and disgraced her memory of her husband that she lived with for 9 years, and it was humiliating. She didn't even come to his luncheon. She was so distraught.
Now, the judge is yelling at the defendant for not reading the will. Before you go to court, a little tip, read everything. And there's no excuse for not reading everything. And that will probably be very important. Let's see.
She went home and she got rid of anything that was in there that reminded her of these people, that disgraced her memory of her husband of 9 years.
We're following the will. That's what we're going to do, because that's all we can do.
You said that they would have to produce the will within 30 days, and I had never seen her here telling no wills.
It's not true. I practiced probate law before I took the bench. That's just not the statement of the law. It's not. Well, all right, this is what we're going to do. We have a will. We have to enforce the provisions of the will. That's what we do. It's the law. And the person who died left everything to Ms. Lepard. That's what he did. And he can do that if he wants to. The only type of items that we're dealing with here are personal property. And Ms. Lepard has indicated that there are only certain items of that she wants. And according to her figures, the cost of those items are $2,981.28. And that's not including the guns, because the guns that are listed in the will do not go to Ms. Lepard. They go to somebody else. So I'm not including those guns at all when I make my ruling here. But she's entitled to those items because the will says that she's entitled to those items. You have a choice, Ms. Chavis. You can give her the items on this sheet, or you can pay her the money. But she's entitled to that because that's what the will says. And I think that you did know about this earlier on. I don't believe it when you say that this is the first time that you've heard of the will here today in court. Well, I just don't believe that. So am I.
I don't know nothing about no will till today.
So I'm going to enter a judgment in the amount of $2,981.28. I will add to that cost consisting of a $65 filing fee, plus a $23 service fee, bringing the total amount of the judgment to $3,069.28.
In the end, the judge followed the law, which is the will, which is in writing. The bottom line, get everything in writing. Chances are the writing will tell you how the judge will rule. If you find that you are involved in a dispute that you can't resolve, small claims court may be the answer. Thanks for watching Case Closed. I'm Charlie Langton. Hello and welcome to